Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. So, in today's day and age, when people are coming into the US, whether they're already here and they're applying for different things, there's lots of reasons under immigration law that they're not eligible, that they can't get in because of something essentially that they have done in the past. Let's just take an example. Let's say that they committed some crime. And under immigration and nationality law, if someone commits this particular kind of crime, they're not allowed to come in. So then the next question is when they cannot come in, what happens when they still want to try? Is there a way? And there is, in actuality, a way under some circumstances that they can still come in. And those ways are known as waivers. So, what does a waiver mean? Well, a waiver, by definition, basically waives or forgets about the ground of inadmissibility and essentially says, okay, we know that what you did was wrong, but for all these various reasons and because of what you properly showed us, we're going to let you in. Okay, that's the sum of what a waiver does. Now, obviously, a waiver to prepare it takes a lot more work, and to get it approved takes even more work. It's not a simple, quick matter, but the law is there, and it does allow, under some circumstances, a lot of circumstances, to get things waived. Now, each kind of waiver has different requirements. Some are similar, some are not. Some are easier, some are harder. It all depends on the law of that waiver. So, for example, let's go back to the criminal, someone who committed a crime. Someone who committed a crime can't come in. Let's say they committed a theft crime and had a sentence of, 6.5 months. And then, they marry a U.S. citizen and they want to adjust status. And let's say minus the crime, they qualify. So what we do is it's an attorney cover letter explaining all the law on why exactly the person's inadmissible, why they qualify for the waiver under what section of law, and then it goes into the actual waiver itself, what the requirements are, what's needed. Now, normally, with a waiver, of course, you have to show number one, the whole history of why they need the waiver, and then you would argue and show why they qualify to get it granted. So you try to show rehabilitation, you try to show good moral character, you try to show all the good stuff. It's like a scale. The crime is the bad stuff, and then you show all the good stuff on the other side of the scale. That's sort of what it comes down to. Now, there normally is a requirement that there be a hardship to one of your relatives if the waiver is not granted. So, for example, again, I'm talking about a marriage petition here. If, let's say, the waiver is denied and you're deported and you can't come back for 10 years, what hardship would that show to your spouse? So, most of the time, there is a definition in the waiver itself of who is what is known as the qualifying relative. So, like for a criminal waiver, it has to be a spouse or parent who's a lawful permanent resident or U.S. citizen. And what that means is that if you have a child who's a U.S. citizen, but you have no spouse and no parent, then you can't do a criminal waiver. Let's say you're marrying a foreign national. Let's say you're still going to do some kind of marriage petition based on employment and your spouse doesn't yet have the green card. Well, then you can't do a waiver if you don't have the qualifying relative. So it is critically important that when a waiver is being done, that you determine if the qualifying relative exists, and then the procedure can go forward. Now, unfortunately, a lot of people, I can't tell you how many times this has happened over the years. They'll just call for a consult and they'll go, "Is this the 601 or the 212?" Like all they need to do is fill out the form I-601 or the I-212, I send it in, and boom, voila, the waiver's granted. It doesn't work like that. The form itself is, kind of like the book cover. And the waiver itself is everything inside the cover. And the immigration officials, whether it's the official at the port of entry, whether it's the one at USCIS making the decision, whether it's at ICE, wherever they happen to be, whether it's the immigration judge, they don't have to grant a waiver. And in fact, the burden generally is against you on granting it. It's harder to get a waiver approved than it is denied. That's the reality. So you can't go into thinking that you'll just write a couple things, say, oh, my spouse will suffer terribly if I'm not there because I'm the breadwinner of the family. That's usually what happens. And then, of course, it's denied because they haven't done a proper waiver and they haven't shown real hardship. They haven't even submitted a psychological report on the hardship as an exhibit. That's just one of the items that normally is needed. Now, 99% of the time, waivers are done for the foreign national. So if the foreign national has committed a crime, has committed fraud or misrepresentation, is likely to become a public charge, has a medical issue, all kinds of stuff like that, then they need to do the proper waiver. If they have crimes that are 15 years old, then it falls into another category. It all depends. But there is one waiver that the US citizen must do. And that is when the US citizen has committed a particular kind of crime, which is a sexual related crime against a minor. And if that person, no matter how long ago it was, it doesn't matter, has that type of crime, then they cannot petition anybody to come into the United States. And this usually comes up with a fiancé petition, with a marriage petition, and their spouse essentially is left without any other options and therefore cannot come in because the U.S. citizen is subject to the Walsh waiver. That's what that's called, and hasn't submitted it. Now, I was telling you previously how a normal waiver is hard to get approved. A Walsh waiver is probably the hardest waiver to get approved. So obviously, it takes a great deal of work and convincing to do it. And sometimes I do look into independent immigration avenues for the spouse so that the Walsh waiver, if it's denied, is not the end of the road. But it is doable. Okay, so if you're a U.S. citizen and you've committed this kind of crime, you certainly don't want to just hop in and try to do the waiver yourself, because the chances are very likely it would get denied. So the bottom line with waivers is that the waivers are the door that must be open for you to get in. So, in fact, where some people think the petition itself is the most important, the consulate processing and so forth, it's not. The waivers are the most important. They're the most difficult to get approved, but they are the most important because without an approved waiver, that person is not coming in. Period, or they're not adjusting status. So all of your eggs need to be in the proper basket to get those waivers done and to get them done right. Okay. So if you like the video, click like, subscribe, and more on the coming weeks. Thank you.